Thank you so much for coming today, and thank you for joining us to discuss the controversial proposition that recently passed in California. Prop 19 potentially affects every California property owner and may have such severe ramifications that we have asked our two most experienced attorneys and tax specialists today to present this information to you. Because of the effective date of this new law, we are working with a very limited time frame to be able to provide the planning that is necessary to ensure your property is handled in accordance to your wishes. My name is Kara Musa, and I am the Director of Marketing for the Kopenbarger & Kopenbarger law firm. Our firm has helped thousands of families just like yours in their times of need, and we pride ourselves on working as a team, not only within the firm, but also with other professionals like our clients' financial planners, CPAs, and other advisors that are instrumental in creating the best plan for you and your family. We are the Kopenbarger & Kopenbarger law firm, and we have been in business for over 40 years. We have 9 attorneys and dozens of support staff that are highly qualified and ready to serve you at any time. With locations all across the state of California, we are able to meet with you in person or through virtual means such as teleconference. In the chat box, you will see a link to our contact page on our website. If at any point during the webinar you recognize the need to schedule an appointment to meet with us to discuss this crucial and time-sensitive planning for Prop 19, please click that link and provide us with your contact information so we can reach out to you right away. Please keep in mind that all appointments will be scheduled on a first-come, first-served basis, so do not wait if you know you need to meet with one of our certified specialists. All planning consultations related to Position 19 must be completed by January 8th, 2020 to allow sufficient time for planning to be implemented before this law takes place. Your presenters today are our founder, Lloyd Kopenbarger, and our senior associate, Robert Galliano. Lloyd Kopenbarger is the founder of our law firm and has been practicing law for over 40 years. Lloyd has a master's in taxation and is a certified specialist in probate, estate planning, and trust law by the California Board of Legal Specialization through the State Bar of California. Lloyd has trained dozens of attorneys throughout the years and has led our firm in serving over 30,000 clients across the state of California. You'll find that Lloyd takes the very complex and makes it simple, and we certainly hope that's what we accomplish for you here today. Robert Galliano is another of the 9 attorneys within our firm. Robert has a master's in taxation and is also a certified specialist in probate, estate planning, and trust law by the State Bar of California. Robert also has a passion for veterans and is a VA accredited attorney. He practices in our Temecula offices and services all surrounding areas in Southern California. Because of the nature of this presentation and the time-sensitive information we must provide you, I cannot stress enough how important it is to schedule an appointment as soon as possible. Without further delay, I'd like to welcome our founder and attorney, Lloyd Kopenbarger, and attorney, Robert Galliano.
Thank you very much, Kara. It is truly a pleasure to be with you folks today. This is an unusual webinar because we're dealing with a crisis subject with a crisis timeline. Now, the difficulty that we're faced with is this proposition which passed because of inadequate information being given to the public, I believe almost fraudulently withheld from the public, has created a situation with really severe ramifications for the middle income class people in the state of California. Essentially, this is the greatest threat to middle income wealth that I've experienced in the 40 years that I've been an attorney here in the state of California. And the difficulty is that the time to take steps to eliminate the problems that this law creates is very limited. As Kara already mentioned, all the planning and all the meetings with attorneys to determine what needs to be done is going to have to be done between now and the first week in January. Now, what I've done in order to serve our clients is ask our attorney staff to make themselves available during the Christmas holidays to help our clients protect themselves if they see the need to try to protect the wealth they have in the form of their homes and other real estate properties. And so, without any further planning, I asked Robert to make himself completely conversant with the law and prepare a presentation to bring to you so you as a layperson could understand the ramifications of this law and the threat it presents to you and the financial resources that you've accumulated over your lifetime in the form of your home. If you are a homeowner who wants your home to be wealth to be transferred to your children, you are in a crisis situation. If you're a child who has been anticipating the wealth that would be transferred to you when your parents pass this life and you inherit the property, you also are in a seriously jeopardized position. And so, without any further delay, I want to introduce to you our specialist in this area of the law. He's not only trained himself, he is in the process of training the other attorneys in our office on all the fine points of this law. And so, without any further delay, I want to introduce to you Robert Galliano.
Thank you, Lloyd. It is also a pleasure for me and a privilege to be speaking to all of you. On your screen right now is the agenda of what we're going to cover. The point number one is that Proposition 19 passed. So now that we have a new law that has passed, what are the implications? We need to understand the previous Prop 13 in order to understand the new Prop 19. So I will cover that. And as always, with every proposition or every law that is passed, there's always good material and bad material. And therefore, I will cover the good and the bad of Prop 19. And again, most important, as Lloyd has already mentioned, is who does this law affect? And more important, the consequences of not taking any action. And again, important for you is how we can help you, that we can. Well, Prop 19 changes the rules for the property tax assessments. And these new rules become effective February 16, 2021. Before we could really understand the changes that have occurred in the law, we first need to have a quick review of what Proposition 13, that was the law that was instituted in 1978, so we can really understand the differences then between Proposition 13 and Proposition 19. So let me go through some slides that hopefully will explain these differences. I like examples. I like to see numbers. I like to see pictures. And therefore, what I've done is I put together this screen for you. And this is an example of a house that was purchased in the 1960s. So parents bought this house, a condo, a 1,200 square foot condo in La Jolla, California. Back in 1960, they paid $50,000 for the condo. And they lived in it for a few years and then rented it out for many years later. And the property then was assessed at $200,000. So they bought the property for $50,000. The tax rules or the tax rates were assessing the property at $200,000. And therefore, the property taxes on the $200,000 assessment was $2,100 a year. All right. Let's move forward to the year 2020, where we are now. Same condominium, location identical, a new family buys this property that is worth $1.5 million. The property taxes, as they're assessed on the value of the home today, what they paid for, is close to $16,000 a year. Now, again, inherited property or the property that was purchased in 1960, the taxes were low. Taxes, same property purchased by a new family, the taxes have now increased. In this example, it's almost like 6 times the tax rate or the tax assessed value. The tax assessment, the tax bill went from $2,100 to almost $16,000. Big difference in property taxes every year. So under Prop 13, as you may remember, if you have been around in the 70s here in California, property taxes were escalating, and then in 1978, laws were passed to try to stop then this unrealistic increase in tax assessment every year, because the property values in California were increasing so much that the property taxes were increasing also, and people could not keep their homes because of the tax bills. So California passed then Proposition 13 in the 1970s, 1978, and they said, okay, property in California is going to be assessed at 1% of market value, but we're only going to reassess the property at 1% of market value if there is a change in ownership. 1% of market value upon a change in ownership. So what is a change in ownership? A change in ownership can be a sale. I sell my house to you, you bought it, that's a change in ownership. I gift it to a child, that's a change in ownership. Or a transfer of death, I leave the property to a child that's been inherited, that was a transfer of death. The transfer from for example, from a revocable trust upon my death to a child, that is a change in ownership. So there are various situations where a change in ownership occurs, and that's where California then comes in and says, okay, there's been a change in ownership. We're going to assess a new tax amount. Now, we in California then were afraid that the 1% could still get out of control. So we also in the law put in that the 1% can increase by a California Consumer Price Index every year, but it's going to be capped at 2%. In other words, the worst thing that can happen under the current Prop 13 structure is that the property assessment can go maximum 2%. Now, we know here in California, all of us know here in California, that the property values increase dramatically every year. Most of the time they do. Now, the average statistically is that they increase about 4% per year. So if the property is increasing around 4% per year and the property assessment is capped at 2%, you can see that there's a disparity then. Property values increasing, tax assessment are staying way below. So California property owners that have owned real estate for a long time have lower property taxes compared to people that are purchasing property today. The example that I gave earlier, the condo in La Jolla, the 1960 assessment of tax, $2,100. The new owners that bought it in 2020 assessed at the value $1.5 million. The property tax was almost $16,000. That is a huge amount of a tax. And that can cause all kinds of problems, inability, for example, for a child or somebody who inherits the property be able to even pay the taxes to stay in the home. So that's Prop 13. And again, property is reassessed when there is a change in ownership, unless there is an exemption. Most laws, as you know, they're passed, but they have an exemption. So there is an exemption to the reassessment of change in ownership, and I'm going to tell you what that one is. A particular exemption that I'm going to be talking about is when parents leave their primary home of any value to their children. There's an exemption that's called the parent-child exemption, and it's also grandparent-grandchild exemption. I'm talking about the exemption, parent-child, grandparent-grandchild exemption. Under Prop 13, current law until February 16th of 2021, parents can leave their primary home of any value to their children without any reassessment whatsoever. I'm going to repeat it. Parents can leave their primary home of any value. What does that mean? Well, a home worth $200,000, or the home can be worth $5 million. It does not matter, because the current law says the parent could leave their primary home of any value to their children without any reassessment. And in addition, California right now under Prop 13, each parent can leave $1 million in a such property value to their children on additional properties. Each parent, that's an additional, that's $1 million each, $2 million worth of property. Current Prop 13. Okay, we got that one? Great, now let's move on. What is the new law? Well, California voted for an amendment to the California Constitution. It was the Constitution Amendment number 11. And what it did is it limits and removed parts of the parent's ability to pass homes on to children without a property tax increase. I'll say it again. Prop 19 basically truncated the ability for parents to transfer homes to children without a property tax increase. And in order to get the law passed, they added a sweetener to get the votes. And Lloyd already discussed about the marketing that was done to get all the votes to pass the law, and that was a tax decrease for seniors. So I'm going to go ahead now and talk to you about the good and the bad of Prop 19. The good part, which is the tax decrease for seniors, this particular part of Prop 19 goes into effect April 1st, 2021. Now, as you can see, we already have two dates, the April 1, 2021 and the February 16th, 2021. That alone is confusing. The good part, seniors over age 55 or severely disabled and victims of wildfires or other natural disasters can move into any higher cost home in the state and retain their lower tax base up to 3 times in their lifetime. Under Prop 13, you can only move once, and that was only to specific counties. And certain counties had to have a they had to be able to move from one county to the other from where your house was to another county. Reciprocity, that's a tough word. So under the new Prop 19, the good part is if you sell your home or replace it with a home of lesser or equal value, you can take the Prop 13 assessment. If you sell your home and buy a replacement home that is more expensive, then the rules are a little bit more complicated. I'm not going to focus on this part of the presentation or this part of the Prop 19 changes because this is the good part. I'm going to focus on the bad part. Why am I focusing on the bad part? Because this is the part that can hurt us. So again, Prop 19, what they did is they basically restricted then the parent to child, grandchild transfers, severely restricted. There's an exception to this rule again. Parent can transfer the property, their primary home, to their child and take advantage of a no reassessment on certain amount, but the child has to occupy the property as their home. Parent to child can be transferred. There is no reassessment up to a certain value, but the child must occupy the property as their home. That's the hook. If the property value, the current assessment value, they added $1 million to that. If the assessment, the new assessment, is the current assessed value plus $1 million, there's no reassessment if the value of the home is under that number. One more time. No reassessment on the current assessed value plus $1 million. If the property is under that number, no reassessment. If the property value currently is over that amount, then there is a reassessment on the amount over the current assessment plus the $1 million. That amount will be reassessed. Other properties besides the personal residence, because I'm talking about the personal residence, they will have their tax base increased to current value upon the parent's death. Remember under Prop 13, you can transfer $1 million of other property besides your home? That's gone. Example, I'm using the same condo in La Jolla. Parents bought the condo, remember, for $50,000. Current value is $1.5 million. Property was assessed at $200,000. The child is going to inherit the property. He files a reassessment parent-child exclusion. The assessed value remains at $200,000. Taxes remain at $2,100 with minor increases per year. Prop 13 example. Prop 19, same home. Home is worth $1.5 million. Assessed value still at $200,000. Child inherits the home, but he must live in the house. The formula is assessed value, in this example, $200,000. Plus we're going to add $1 million to it, that's the rule. So the assessed value plus the $1 million is $1.2 million. So as long as the property is under that number, there's no assessed value, there's no reassessment whatsoever. But if the property is greater, like in this example, $1.5 million, that's over $1.2 million. That's a $300,000 increase that's added to the current $200,000 base. And now the new assessed value is $500,000. Taxes are now over $5,000. We more than double the taxes on the property. You can see the difference then, what happens, okay? Under Prop 19, the parent-child exclusion still exists, but it has been truncated. It's been restricted. And these are the rules that we understand. And we want to make sure that you understand what the issues are. And Lloyd is going to explain in more detail some of the laws that we have to understand and apply in order to help you. I want you to understand one thing. This new law is effective, this part of the law February 16, 2021. In order to avoid any potential problems, because we're going to be dealing with governmental entities and so forth, we want to make sure that any deeds that are going to transfer property have to be signed no later than January 31, 2021. The planning has to be done now. We're emphasizes the need, the urgency of the planning and meeting with us. Again, this law only passed by a small margin, 51% against 49. And they promoted it really what the advertisement was to eliminate the tax loopholes for celebrities and wealthy East Coast owners. Now, are you familiar with the Lebowski movie, right? The Great Lebowski? Well, what they did is they coined this a Lebowski loophole. What is a Lebowski loophole? Well, Jeff Bridges inherited property in Malibu years ago, excuse me, with a very low tax base. Now he can rent the property for almost $15,000 a month. The income alone from that property can pay for years of the tax assessment. So that's what they call the Lebowski loophole. And that's what they were trying to close. Is this important to you? This law matters to you if you own a home, you have other residential property that you plan on passing over to your children or your loved ones, or you plan to inherit property from your parents, but you don't really want to live in it or plan to live in it. We want to make sure that your family is really protected. There are a lot of family dynamics that have to be considered when we have the discussion with you. The family dynamics, for example, there may be one child that wants to live in the house. What are you going to do? You're going to leave the family residence to one child when maybe you have other beneficiaries that are going to be, they're going to feel left out. It might cause friction between your beneficiaries. So you have to make sure then that your family is really protected. You might have a distribution that you want it to be equal among kids. So how are you going to do that? Rental homes may be in your portfolio, and vacation homes that you want to stay in the family. So these are all issues that have to be dealt with. I'm now going to pass it over to Lloyd, and he's going to talk to you more about the things that you have to consider in the planning.
Thank you very much, Robert. One of the problems with this Prop 19 is that it sounds like it could be implemented and solved very easily. And the primary tool that people think about is gifting the property to their children right now and getting it out of their name. But there are a lot of problems with that, and I want to spend a few moments talking about them, because you can literally jump out of the frying pan into the fire if you don't understand the potential problems that are involved. First of all, when you gift property to someone else, you lose control. And many times children can get involved in circumstances that can cause risk to the parents through no fault of their own, and with the parent having no control to keep it from happening. Also, you have to be concerned if you have property that is in areas subject to rent control, because you literally can have a situation when that property goes to the child. It's the reverse of the Lebowski situation. You can end up with a situation where the property will not rent for enough to pay the property taxes on the property. And more importantly, in many cases, if you're a person who is concerned about long-term care planning, gifting property will prevent you from qualifying under Medi-Cal for a 30-month period. And what that means is that if you needed long-term skilled nursing care and you needed the assistance of Medi-Cal, you would not qualify to receive Medi-Cal benefits for a 30-month period after you made the gift. And we're also being faced with a couple of other problems that are on the horizon but are not yet firmly in view. The new administration has told us that they intend to increase the capital gains tax from its present level of about 15 to 25% to a 40% level. If that happens, the combined capital gains tax and the state of California tax would mean that the property tax on sale or on transfer of the property for sale purposes would be more than half of its value. And there's also discussion of eliminating the step up in basis on property at the death of the holder of the property. And so that would mean that any person who inherited property would end up with the same cost basis as the person they inherited from, and everything above that cost basis would be subject to the capital gains tax. And then to add insult to injury, the federal estate tax is presently set to sunset. Right now, the amount that a person can leave free of federal estate tax at their death, what is referred to as the applicable credit amount, is a little over $11 million. In 2025, under present law, that is going to revert to a little over $5 million. And there's been discussion in the news media recently that the new administration is even considering reducing that to a lower level whatsoever. One of the problem things that you and I as citizens have to face is when politicians talk about taxing the rich, they're usually talking about the middle class, the working class. And so this change in the law under Prop 19, coinciding with any changes that might occur in the federal income and estate tax laws, could be absolutely devastating to the wealth that you have planned on leaving to your family when the time comes. So these are issues that are very seriously complicated and have to be addressed if you're in a situation where this law is going to affect you and the plans you have for the disposition of that property when the time comes. Now, one of the things that we need to talk about are the steps that the law firm of Kopenbarger and Kopenbarger has implemented to try to protect you. First of all, I think I already mentioned that our attorneys have agreed to make themselves available through the Christmas holidays to be there to protect our clients. But for us to do this, it's going to require consultation with those people who believe that they're in need of protection. And for that, we're charging $550 for 1 hour in-depth tax analysis of their circumstances so we can determine what steps can be taken to protect them from this draconian law. We also are limited on the number of people that we can see. Just the people who are at this seminar would come close to filling our calendars completely. And so if this is something you believe you are going to need, this is a first come, first served situation, and we have no choice about it. We only have so many attorneys with the capability of helping you. All of them will be available, but we have to know ahead of time because everything has to be done so that we know what we're going to be required to do to protect you by the 8th of January. And then the work actually has to be completed before the 16th of February, which effectively means the first week in February when you consider the holidays. Now, in review, let me discuss with you again what Proposition 19 means. First of all, it affects all homeowners in the state of California, whether you have a very modest home or whether you have a mansion. That law is going to affect you, and it's going to affect the values that are in that home when you transfer it at your death or by gift. If you don't accomplish protection before the new law goes into effect on February 16th. If you are a person who is inheriting property or anticipate you're going to be inheriting property, this law is going to significantly decrease the value of the inheritance you're going to receive. And so it is something that if you have a parent who is looking forward to leaving their home to you or to you and your siblings, it's something you need to sit down and talk to your parents about the seriousness of dealing with this and dealing with it promptly. We as attorneys can help you identify areas where there can be conflict generated by your attempts to protect the value of the property for certain individual members of the family. And we can help you balance your financial resources in such a way that protecting the values in the home does not necessarily deprive the other children of the inheritance that they would be entitled to expect and receive. We can help you understand the new law and what it means to you and your individual circumstances. That's another problem with this law. Every person brings a different scenario to this law. And so there is no one size fits all solution to it. And it's going to require someone who knows and understands the law to be able to determine what can be done to protect you and protect the resource that you have in the form of your home. And remember, everything has to be underway no later than the 8th of January. So we're dealing with a very finite time frame, a very set schedule that has to be followed to provide protection. And so I encourage you, if you see this as an area where you're vulnerable, where you're in need of protection, don't delay, act now. And I would very much hate to say to any of our existing clients, I'm sorry, we no longer have time available to help you. That would crush the creed that I've lived by as your attorney for the last 40 years. And so don't put me in that position. If you're a client and you see you're going to need this, you get on the phone, you call in and make an appointment. If we have time available, we will make availability to everybody. But I'm primarily concerned about protecting those people who've entrusted their affairs to us all these years and making certain that they and their families are protected to the extent the law will permit us to do so. And so without any further delay, I want to turn you to the person who can help you accomplish the setting of these appointments. And I want to introduce to you again, Kara, and she will provide help to you.
Thank you, Lloyd. Again, we would like to thank all of you for attending our webinar today and hope you received valuable information about this new law that affects so many of us in California. For those that need to meet with one of our tax attorneys to discuss your options, please refer back to the link in the chat box and we will reach out to schedule your tax appointment now. Because of the complexity of this planning and the short amount of time we have to accomplish it, we are only taking appointments until the first week of January. You must meet with us before then to protect your home for yourself and those you wish to pass it on to. Lastly, we want you to know that we are here to help you through all stages of life, whether it's setting up an estate for the first time or protecting your precious assets when new laws like this pass. Lloyd Kopenbarger has had a phrase that he's used for years, and that is, if your attorney isn't there when you need them, then you don't need them. We truly take that to heart, and we will be here when you call. Have a great rest of your day. Thank you.